Council, our apologies. We will get started as soon as we can clear up this technical difficulty, but at least we don't have a cat on screen. All right. Good afternoon and welcome to the Appellate Division First Department. Our apologies for our late start. We were having some technical difficulties in this virtual world we now live in. And now to begin with the call of the calendar, Council, please pay attention for your case name. People versus Espinal, submitted. 602 10th Avenue versus Estate of High Nusinau is submitted. H. Children, submitted. Irby versus 36 LLC, appellant.
Alan Zachary for the appellant.
Good afternoon, Mr. Zachary. You've been granted 5 and 1. Respondent.
Good afternoon, Your Honor. Dave Zegarelli for respondents.
Good afternoon, Mr. Zegarelli. You've been granted 5 minutes. Kim versus Francis.
Good afternoon, Your Honor.
Appellant.
Good afternoon, Your Honor. Kenneth Gorman for the appellant.
Good afternoon, Mr. Gorman. Please keep your voice up when we go into argument so we can hear you. 5 and 1. Ms. Steger.
Good afternoon, Your Honor. Kara Steger for the respondent.
Good afternoon. You've been granted 5 minutes. Regales Construction versus Wonderworks. Appellant requested no time. Respondent, Mr. Perlman.
Afternoon, Your Honor. Daniel Perlman for respondent.
Good afternoon, and you've been granted 4 minutes, sir.
Yes.
People versus Wanko is submitted. Levin versus Salvini. Mr. Butt for appellant.
Yes, good afternoon, Your Honor.
Good afternoon, sir. You've been granted 5 minutes, and I hope I don't mispronounce your name, Mr. Greilsheimer.
Very good, Your Honor. Jeffrey Greilsheimer for the respondents.
Wonderful. You've been granted 5 minutes. People versus Richardson. Miss Schriefter?
Yes, Schriefter. Good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1. Ms. Reagan.
Yes, good afternoon, Your Honor. Amanda Reagan for the people.
Good afternoon. You've been granted 4 minutes. Banco Indusval versus Gonsalves. Mr. Zelbo.
Good afternoon.
Good afternoon. You've been granted 4 and 1. Mr. Levinson.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes.
Thank you.
Ging versus FJ Shiam and others. Appellant respondent Koenig. Mr. Cheng.
Good afternoon, Your Honor.
Good afternoon. You've been granted 7 and 1.
Thank you, Your Honor.
Respondent appellant Atlantic, Mr. Kaminska.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1.
Thank you.
Respondent appellant for Shiam, Mr. Rubenstein.
Yes.
Good afternoon. You've been granted 4 and 1. And respondent Ging, I'm going to need help with the pronunciation of that name because I know I'm not going to say it right. So please help me out.
Always got it right in past, Your Honor. Joseph Kazmachek.
Say that again.
Joseph Kazmachek. You've always gotten it right.
Okay, wonderful, Mr. Gazmerchek. You have been granted 5 minutes and welcome. Steph Lay Associates versus Wiener Architecture. Mr. Myers for appellant.
Yes, Your Honor. Mr.
Good
Myers.
afternoon. You've been granted 4 and 1. Mr. Henry for respondent.
Yes, Your Honor.
Good afternoon. You've been granted 4 minutes. People versus Yarbrough is submitted. Herrero versus 2146 Nostrand Avenue and others. Appellant respondent for 2146 Nostrand, Mr. Smith.
Judge Renwick is going to call me.
Ms. Rojas, we can hear you. Mr. Smith,
He checked in.
okay. Hopefully he will answer the call during the calendar. Well, in either case, you guys are the
I'm
last
sorry.
case on the
I'm terribly
calendar.
sorry, Your
He
Honor.
has been
I was on
granted
mute.
5 minutes.
Yes, here. Thank you.
Okay, wonderful.
Sorry about that.
Respondent appellant for Shamut, Mr. Zavante.
Yes, I'm here, Your Honor.
Good afternoon. You've been granted 5 minutes. Respondent JD consultant, Mr. Zegarelli.
I'm
You've
still
been
here.
granted 3 minutes.
Thank you, Your Honor.
I heard you earlier, so I know you're there. Respondent Trison, Mr. Lipsky.
Good afternoon, Your Honor.
Mr. Lipsky, we can't hear you.
Good afternoon, Your Honor. Can you hear me?
Now, barely. You're going to have to turn your volume up for argument, and you've been granted 4 minutes. And finally, Respondent Herrero, Mr. Finkston.
Good afternoon, Your Honor.
Good afternoon. I can hear you clearly, and you've been granted 4 minutes.
Thank you.
First case on the calendar, Baron Irby, Mr. Zachary. You have 5 minutes.
Good afternoon. May it please the court, representing the appellant plaintiff. It's our position that the lower court erred in dismissing plaintiff's labor law 240 case. The state of the case under both falling object and falling worker theories. The falling object theory, the AC unit that fell on the plaintiff should have been secured for the purposes of the undertaking. It was foreseeable that this recently installed AC unit would come loose and fall as the plaintiff was attempting to connect it to a nearby air duct with a canvas connector, small, made of fabric that has metal built-ins that had to connect one to the other. And the purpose of it is to.
What's your response to the argument that it's a permanent structure that was meant to be permanently installed there?
Under the case law, something that falls, even if it is a permanent structure, can nevertheless support a claim under the labor law 240 if it was foreseeable that it could come loose. So, for example, there's cases where a kitchen ceiling collapses while someone's has done work on the wall. And in that case, the court found that there was an issue of fact as to whether it was foreseeable that it fell. And here we have evidence that it was foreseeable that the concrete ceiling that the AC unit had recently been attached to was it was an old pre-existing ceiling that had the strength and the stability of it was unknown. It had not been tested. And plaintiff's expert testified that under those circumstances that the practice should have been to further secure it with either braces or stays to prevent it from falling while the plaintiff was working on it. Now, he wasn't touching it at the time that it fell.
Mr. Zachary,
Yes,
your audio is quite problematic, and it is essential that you speak slowly, because when you speed up your speech pattern, then the voice kind of garbles up and we cannot understand you. It's hard to understand you when you speak slowly. So you cannot speak quickly, because then we cannot capture what you're saying at all. Okay?
Okay. Thank you, Your Honor.
Sorry.
I will slow it down. The main point is that there's evidence that it was foreseeable in this instance, and so it doesn't matter if it's a permanent structure or was meant to be permanently installed. Now, I will point out that the installation of the air conditioning unit wasn't fully complete as defendants had suggested it was, because it still had to be attached to the canvas converter and connected to the duct system in order for it to be fully operational. And that's what plaintiff was doing at the time. And plaintiff's expert has opined that it was, or has said, given the unknown strength and stability of the ceiling, that it was foreseeable. Now, there's also a claim based on a falling worker theory. The plaintiff's expert opined that because the plaintiff's actions in installing the canvas converter required a pushing back and forth motion, he should have been provided with a more stable device instead of an unsecured ladder. He should have been provided with either a scaffold or a scissor lift. And there's other cases where a similar expert opinion has been sufficient to defeat a motion for summary judgment on the basis that the device that was provided to plaintiff wasn't appropriate for the work he was doing or she was doing, and therefore there was a violation of the statute.
Okay, well, you have a minute on rebuttal. Okay,
Thank you, Your Honor.
so thank you. Mr. Zagarelli, we'll hear from you now. You have 5 minutes.
Thank you, Your Honor. May it please the court again, Dave Zagarelli. I'll cut right to the chase. This is not a falling object or a falling worker case. It's not a falling object case because the AC unit did not partially detach from the ceiling due to the absence or inadequacy of an enumerated safety device. It's undisputed, already a permanent fixture by the time the accident occurred.
Well, wasn't that part of the job here?
The job, correct, but with respect to the AC unit,
it was permanent as of the day before it was installed?
The AC unit
Isn't that an issue of fact?
Not at all, Your Honor. Not at all, Your Honor. It's undisputed. Plaintiff testified it was permanently installed. That's why there was no expectation that it would partially fall.
To be permanently installed. And one day later, the entire device that is supposed to secure that unit to the wall fails and falls on this worker.
Your Honor, respectfully, this is Fabrizi all day long. Just like screw couplings are not safety devices, neither are metal support rods. This AC unit, no one knows why it partially detached, Your Honor.
Well, what is it about an AC unit that is partially extended out of a edifice? What makes it permanent? There has to be something that structurally attaches that unit to the building to make it a permanent feature.
Correct, Your Honor, and that is the metal. Your Honor, right, correct. That the 4 permanent metal support rods. The purpose of those rods is not to function as a safety device or to provide worker protection.
Wait. They put them there not for adornment. They put them there in order to secure them so that they don't fall from the building. No?
I understand that, Your Honor. That is correct.
So the answer is yes. These items are placed to secure that unit in order to make it a permanent feature of the building. But
Your Honor,
let me finish my question, counsel. If the very item that is utilized to create a permanent fixture to a building fails within 24 hours of it being affixed, can we say as a matter of law that that constitutes a permanent structure?
Yes, Your Honor. I go back to Narducci. Remember Narducci?
Oh, I'm glad you brought up Narducci.
But it's true, Your Honor. Again, respectfully, at the end of the day, this is all about permanency. The function.
So didn't the court in Narducci make a point in that decision of noting that the glass window that fell had been installed before that construction began and was there before the construction began, which is completely different from our case, where the AC was being installed as part of the very job that this worker was working on and was not there before the job began. So doesn't that make Narducci distinguishable, at least to the extent of finding that there should be an issue of fact as to permanency?
I respectfully disagree, Your Honor, because at the end of the day, the AC unit, it's undisputed, was permanently installed. It was in its final condition, meaning it was completed and not in need of temporary support.
Counsel, wasn't work still going on at that same work site that was part of the AC installation? I mean, the work that this worker was doing was not separate and apart from the AC installation. It was part of the very work that was connected to the installation of the AC. No, this is a case like a lot of the falling object cases where it had been affixed for a while and the worker came in and that was the way things existed. The work was going on as part of his work.
Correct. No, I understand, Your Honor. I know you're saying I'm looking at this in a vacuum, but respectfully, I submit the factors are in my favor. Again, as plaintiff also indicated as well, and just like in a lot of the cases that plaintiff relies on, here, plaintiff was not touching the AC unit at the time it fell. The canvas connector he was installing was not touching the AC unit at the time. Plaintiff also testified that he never saw this AC unit shake or move.
So are you suggesting that if at the moment that the AC fell on top of him, he had been in the act of trying to connect this device to the AC unit, that would make a difference? Somehow that would make it a non-permanent structure?
No, I'm not saying that, Your Honor. But what I'm saying is in a large body of case law, the plaintiff is actually touching or otherwise working on the object that inevitably moves. We don't have that here at all. Again, and I know at this point I'm repeating myself, but it's my position that the facts are clear. This AC unit was permanently installed in its final completed condition at the time of the accident. There was no need for temporary support whatsoever.
Do you want to address quickly the issue of the lack of other equipment like a scaffold before since your time has run out, I will give you a little time to address that issue.
Thank you, Your Honor. You're alluding to the opinion by Kathleen Hopkins that plaintiff should have been provided with a scissor lift or Baker scaffold because of all of the pushing and pulling movements his work required. There's a problem with that. Number one, plaintiff never testified about any pushing and pulling movements. And number two, even more importantly, he didn't fall off the ladder because of pushing and pulling movements. He fell off the ladder because he lost his balance after he got hit in the head by the AC unit.
But that's the whole purpose of a scaffold, no? So that if something hits you, you have a better shot of not falling. If you are on a scaffold with railings where you fall is just on the platform you're standing on rather than feet below.
I understand that, but Your Honor, respectfully, it's also complete speculation to say he wouldn't have even fallen off those devices, even if they had been in place. That's my position.
Does the case law say that we have to be able to establish that had a scaffold been used, the worker would not have fallen in order to consider that as a viable issue?
No, I'm not saying that, Your Honor, but what I want to focus on is the safety device he had been provided at the time. By plaintiff's own testimony—
Which was what, the ladder?
Correct. There was no issue with the placement, stability, or sturdiness of that ladder. Most significantly, though, too, it did not move in any way, in any shape or form during the entire accident sequence. There was no defect. It was adequate. There was no malfunction. It was not improperly served. At the end of the day, let me just say, Your Honor, respectfully, counsel's arguments at bottom is that because plaintiff fell from a freestanding ladder, he has a viable 240 claim. But a freestanding ladder—
Counsel, you're out of time.
I'm sorry, Your Honor.
I've given you about 3 minutes extra. Thank you.
Thank you. I appreciate
Mr.
it.
Zachary, you've got 1 minute. You've got to unmute your mic.
I just want to add on that last falling worker issue that, there are cases where it says, where similarly experts have opined that instead of a ladder could have used a bigger scaffold or man lift because that would be a more appropriate device for plaintiff's work. And the court in this case has said, raised an issue of fact that whether it could have prevented plaintiff from falling once he was being trapped. So, for example, there's cases where someone is electrocuted while they're doing work, and the 240 claim has been upheld on the basis of expert opinion that the device provided did not adequately protect them. They should have been provided with a more stable device. And unless there's any further questions, I yield my time.
Thank you so much. Kim versus Francis. Mr. Gorman, you have 5 minutes.
Good afternoon, Your Honor. Kenneth Gorman for the plaintiff. There is not one reported decision where a Supreme Court justice had sanctioned an attorney for citing to an appellate division case at oral argument because it was not cited to in his papers. Rule 130 states that conduct is frivolous if it is completely without merit in law is undertaken to delay the resolution of litigation, harass or maliciously injure another, or asserts material statements of fact that are false. The trial court's sanctioning of me for citing to this court's decision in Viacom because it was not cited to in plaintiff's papers conflicts with the wording of Rule 130. One of the main reasons why Rule 30 limits sanctions to attorneys who act in bad faith is to avoid inhibiting lawyers from making legitimate arguments out of fear that their conduct could be erroneously deemed improper. I informed Justice Maisley that the case was an appellate division decision and a matter of public record. And under CPLR 4511, every court shall take judicial notice of the common law, constitutions, and statutes of New York State and the United States. Since Justice Maisley had no basis in law or fact for sanctioning me, the sanctions award should be vacated. Thank you.
Thank you. Ms. Steger?
Good afternoon, Your Honor. Kara Steger again on behalf of the respondents. I think that the appeal, it's important to understand that the appeal brought today is from two orders, a January 2020 order of the court at oral argument and a subsequent April 2020 written order that followed. And the appeal asks two questions. One, did the court below abuse its discretion in awarding defendant sanctions in the amount of $3,562.50? And two, the appeal asks that Justice Maisley be removed from the case for issuing an order that it was not favorable to the appellants. The January 16th, 2020 oral argument was an argument to address multiple motions made by respondents, a motion to dismiss their amended complaint, and also a motion for sanctions. A motion for sanctions that had been fully briefed prior to that oral argument, and during that briefing period,
well, which did not involve this counsel, correct?
This counsel, he was arguing that motion. So he appeared at oral argument. He didn't draft the papers for that motion, but he was there to argue that motion that had already been fully briefed.
Right, I understand, but the underlying acts that were the subject of that motion were not acts by Mr. Gorman.
So the party that was sanctioned was Sunshine Firm, which is the firm that represents appellants in this action, and Mr. Gorman was appearing on behalf of the Sunshine Firm. So they are the party that was sanctioned, not Mr. Gorman as an individual.
Okay, so it's the other way around. Sunshine gets sanctioned for arguments made by Gorman.
But he did not get sanctioned for arguments made by Gorman. The sanctions arose from a course of conduct that has been taking place since the start of this action. And that's why it's so important to view it from the framework that this is an appeal of both the January 2020 order and the April 2020 order that followed and clarified in detail the reasoning for those sanctions. And that reasoning included the course of conduct throughout that was detailed in that briefing period that's happened throughout this case. And what counsel is referring to, the citation to the case on January 16th, 2020 was not the sole reason for the sanctions, but was rather the final straw.
Counsel, before you run out of time, can you quickly address your argument that the appeal was not properly perfected and should not even be considered in the first instance?
Well, the appeal was not properly perfected on the issue of removing Justice Maisley, because that was never brought in the court below. The issue of recusal was never brought in the court below. There's no evidence of bias on the record. And in addition, the counsel is appealing sanctions awarded to Gerard Adams, who is not listed as a respondent in this appeal.
Are you saying that Mr. Adams wasn't served with a copy of the notice of appeal?
I am saying, yes, that's correct.
And the impact of that.
I'm sorry, go ahead.
And the impact of that is what?
I represent in the court below defendant David Arabov, and this appeal was served on defendant Arabov and served on defendant Jonathan San Pedro, neither of whom were awarded sanctions in the court below. So we have responded to this appeal simply because Mr. Adams, who was the party who was awarded sanctions, wasn't served with the appeal, wasn't named in the appeal, and also because we feel that there's no reason for Justice Maisley to be removed from this case whatsoever. Counsel does not point to any bias in the record. Justice Maisley has made decisions for appellants, against appellants, for respondents, against respondents, according to the law. And there's simply no extrajudicial basis to remove Justice Maisley. So we felt it was important to appear on that basis and put in an opposition. But yes, we weren't awarded sanctions, and the party that was not even served with this appeal.
Thank you. Okay, Mr. Gorman, you have 1 minute.
With regard to Mr. Adams, he was served with the notice of appeal, but he didn't sign up to the e-filing process, which is why he was not served with the notice of with the record of appeal and the briefs. And I went over that with.
Excuse me, you're saying that we have 2 affidavits of service, one for each notice of appeal served on Mr. Adam?
I believe so, and I'll double check.
Where in the record?
I don't know.
That without that, it seems that is a fatal problem. So unless you can tell us where we can find proof of that in the record, we can't move forward to the substantive issue without getting past this procedure.
Let me answer that, because even if there's a notice of appeal, if you didn't actually serve the brief, it's the same fatal flaw. So it's irrelevant if you serve the notice of appeal, if you didn't serve the brief, and if you're acknowledging you didn't serve those papers, you're acknowledging that there's a fatal flaw that prevents us from considering the appeal.
I'm not sure. I talked to my printer. He said that he followed all of the procedures according to the appellate division with regard to e-filing and service of the briefs. And I will double check with him, but I believe he served hard copies on all parties. Whether he was served with but he did not sign up for the e-filing procedure as was required by all parties. That's what I believe my adversary is discussing. But with regard to service, I believe all parties were properly served with all hard copies.
Yeah, counsel, Judge Kern has phrased this better than I did. My notes say that there's no indication that there was a copy of the record and a copy of the brief served on Mr. Adam, who is in fact the person who was awarded the sanction.
I will go over this with my printer. He told me that everything was properly served. If not, I will let the court know immediately after I discuss it with him. I will call him after oral argument, and I will get. I will find out.
Counsel knows whether we need the affidavit of service, because it doesn't matter if your printer told you was served. What we go is whether and there is no.
I understand.
In the record, which is a problem. No matter what you find out after that, even if it did turn out it was served, if there's no affidavit of service, we can't verify that as part of the record.
There is an affidavit of service. I'll have it filed by with this court today by 5 o'clock this afternoon.
Okay, thank you.
Thank you.
Regardless, Construction versus Wonderworks.
Thank you, Your Honor. Afternoon, Your Honor.
Mr. Perlman.
Yes. Thank you, Your Honor.
Proceed.
This is the subcontractor case in which the subcontractor, Regalis, sued Wonderworks for work that it did at 26 separate job sites on 26 separate invoices ranging from $100 to $8,700. Usually, the invoices were $1,000 or $2,000 and spanned a period of 2.5 years. A judgment was entered in favor of Regalis. I'm sorry, judgment was awarded to Regalis for $54,000, which is the amount that it sued upon. The notice of appeal was not just from the judgment in favor of Regalis, but it was also from the dismissal of the Wonderworks counterclaim, which was for supervisory services allegedly rendered at the request of or at agreement with Regalis, which was denied. The court dismissed that. The court credited the testimony of the father and daughter witnesses on behalf of Regalis and did not credit the testimony of WonderWorks president. In her reply brief, counsel says that the court placed too much emphasis on the credibility of witnesses. I would say wow to that. And counsel argued that the court should have paid greater attention to the physical evidence, meaning the exhibits. I would refer your honors to the record at page 522 and 548. That was the invoices supposedly rendered to Regalis for the supervisory services at $200 an hour by the WonderWorks job super.
Counsel,
Go ahead.
Can I ask you to focus on two things?
Yes, of
One,
course.
the work at the apartment of the WonderWorks president, and the other, the invoices pertaining to 942 Madison Avenue.
Well, with respect to the work that was done at the president's apartment, if the argument is simply that that we should have sued the individual, this was a job like all of the other jobs where Regalis was asked to do work at the apartment, and Regalis did work at the apartment. It was interesting, of course, because this Joseph Kleinberg, whose apartment it was, and he's the president of the company, said, "Oh, I didn't ask him to do anything," and yet he was there when the work was being done. But again, if they're making the argument that we should have been suing Joseph Kleinberg personally and not WonderWorks for that couple of $100 job, I don't know what to say. It was invoiced way back when. Nobody objected way back when. At trial, that's the argument that they made. There was a grab bag of excuses for not paying the invoices. From Regalis was never asked to do the work, to vendors' bills were paid instead of paying Regalis, but the invoices all took account of credits for direct payments from WonderWorks to vendors. And then they had an excuse that Regalis waived its monies owed to it on a particular job, I think on West 35th or West 36th Street, because the architect customer had filed for bankruptcy. There was no proof of a bankruptcy. There was no proof of a waiver.
Mr. Perlman, in the 30 seconds you have left, what would you like us to do?
I would like you to affirm the decision of the court below, which was well reasoned.
Okay, thank you so much.
Thank you.
Norberto Jorge Levin versus Carlos Luis Salvini. Mr. Butt, you have 5 minutes.
Thank you. Good afternoon, Your Honors. May it please the court, Samuel Butt. The motion court erred below to the extent that it granted defendants' motion to dismiss as to claims by Levin Brazil or Levin Argentina, or conversely, did not grant plaintiffs' motion to amend to add Levin Brazil and Levin Argentina as parties.
Mr. Butt, excuse me, your briefing on appeal pretty much, if I got it right, pretty much reflects your argument, your motion and argument below before Justice Schechter. Essentially, you view the operative language in the contributors agreement as including Levin Brazil and Levin Argentina as related companies linked to the contributors, so that Mr. Levin should be able to add them as the court allowed you to add the fund, correct?
Correct, Your Honor.
Yeah, that's the heart of your position. The problem here, as Judge Schechter pointed out below, and as your adversary will probably raise, if your argument is right, then it would suggest that companies related to the contributors couldn't do the work of the fund because it would be an inherent conflict. And what the reasonable interpretation that the court below made was that when it was referring to related companies, it was referring to, and my learned colleagues will forgive me because my Spanish is not good at all. It was relating to, example, Real Valor. I know it's got to be pronounced differently, which was the company that was that actually competed with Levin Brazil to take away the project and create the problems that caused Mr. Levin as a contributor, who ultimately is controlling the fund now, but back then he had over 6 investors, to lose all that money, correct?
Well,
I know you don't see it that way,
your statement,
but that appears to be what was going on in the colloquy that ultimately led to Justice Schechter's decision to dismiss the case against Levin Brazil, and or not to have jurisdiction to be able to have Levin Brazil and Levin Argentina in the mix, correct?
Well, I certainly don't disagree with your recitation of what transpired here between the parties, or between Levin Brazil and the defendants. But I would respectfully say that I don't think there is a inconsistent or illogical reading of related companies. First of all, in section 10.1, which is the jurisdictional provision, it is not the defined term related companies that is used elsewhere in the for example, the non-compete and elsewhere within the contributors agreement. The non-compete, section 8.1, has a defined term, related companies, and it's defined earlier in the contract. The jurisdictional provision just does not have the capitalized terms. It just has companies related to one of the contributors. And I think that can be taken in its general understood meaning. And certainly there can be no question that Levin Brazil and Levin Argentina relate to Mr. Levin. For example, he's the president of Levin Argentina and is generally in control of Levin Brazil. So I hope that answers your question, but I don't believe it is inconsistent or leads to a illogical result, our interpretation of it.
Counsel, how do these claims, one of the requirements is the claims have to relate to something under the agreement. How do these claims relate to the agreement itself, to the contributors agreement, as opposed to a separate claim having to do with real valor and a competing business?
Well, they relate because the claim is a breach of the non-compete provision in the contributors agreement. The claim is that the defendants breached their non-compete, which plainly related to the operating companies, including Levin Argentina and Levin Brazil. Indeed, though they're not mentioned specifically by name.
That's a claim being asserted by the fund, the breach of the non-competition. That's the fund's claim. Why would these two entities have that claim under the agreement, since they're not a contributor?
Well, Your Honor, I don't disagree that the fund can assert that claim, and indeed it has. The reason we are trying to have Levin Brazil and Levin Argentina included, which we believe is proper, is because defendants have made the argument that the fund cannot obtain those damages that were suffered by Levin Brazil and Levin Argentina. Our position is the fund suffered damages by virtue of the same conduct, and it can recover. But and we view the damages as the same. But to the extent defendants have made this argument, we are trying to ensure that we are preserving the fund and Mr. Levin's rights with respect to all the parties, so that he's not required to be having a claim here and claim in Brazil and a claim in Argentina. And we believe under the terms of the agreement and the fact that the non-compete plainly covered the operating entities, Levin Brazil and Levin Argentina, he should be permitted to pursue those claims here, or those entities should be.
Any other questions? He has no rebuttal time, so if you have any other questions, we should lodge them now. Hearing none, thank you, sir. And Mr. Gralsheimer, you have 5 minutes.
Thank you, Your Honor. Jeffrey Gralsheimer of Foxhorn and Camerini for the respondents. This is quite simple. The sole basis for any of this case being present in New York is the jurisdictional provision in the contract. And the claims of Levin Argentina and Levin Brazil do not arise under the contract. They are not parties to the contract, and they are not intended third-party beneficiaries of the contract. And because of that, they cannot enforce any provision of the contract. As a result, their claims cannot be heard in New York. On the intended third-party beneficiaries issue, the parties referenced two different cases from the New York State Court of Appeals on that point. The plaintiffs relied on CalPERS against Sherman and Sterling. And it's very important to note in that case, the Court of Appeals laid out a three-part test. The third part of that test requires that the benefit to the third-party beneficiary be sufficiently immediate rather than incidental to indicate an assumption by the contracting parties of a duty to compensate that party if the benefit is lost. Here, the penalty that is allowed, or the damages provision in this contract, specifies that in the event of a breach, it is the remaining contributors who are to be compensated for that breach. That is, the non-breaching contributors are the recipients of whatever damage award might be appropriate. That is as clear as you can get, that the intent was to protect the contributors and not to protect other parties, notably Levin Argentina and Levin Brazil. The other case that was cited was Dormitory Authority against Sampson Construction Company. And there a two-part test was suggested. One is the party is that the only party can recover for the breach of the contract. Well, here you've already heard from Mr. Butt that the fund, and certainly Mr. Levin, who is also a plaintiff, would be entitled to recover under the contract. So we do not have the only entities being able to recover as being Levin Argentina or Levin Brazil. The other is a possibility that there must be clear language in the contract showing an intent to permit enforcement by either Levin Argentina or Levin Brazil. And if we look at this contract, and I should reference that the dissenting opinion in Dormitory Authority against Sampson went so far as to complain that the decision was establishing a standard that was so high as to essentially be requiring, or come perilously close in the judge's own words, to requiring that the contract name the intended third-party beneficiary. We are not anywhere near that in these contributors' agreements. There is no reference to Levin Argentina or Levin Brazil. If there are any questions from the court, I'd be happy to respond to them, but otherwise, I think I've heard questions from the judges on the first half of this argument, and I don't believe there's anything else I should cover.
Thank you so much. Okay. Have a good day, gentlemen.
Thank you.
People versus Stewart Richardson. Ms. Schriefter, you have 4 minutes.
Yes, thank you. Emma Schriefter from the Office of the Appellate Defender on behalf of Mr. Stuart Richardson. Without first being provided his Miranda rights, Mr. Richardson was subjected to a custodial interrogation, and he was commanded to enter the building, to show the officers his hands, to stand near the wall with his hands by his side, and the officers stood in front of him, blocking his path. For nearly 15 minutes, the officers asked Mr. Richardson questions designed to elicit a confession, not to further investigate this theft.
Counsel, assuming I agree with you that Miranda should have been provided prior to questioning Mr. Richardson here, why, under the facts of this case and on this record, with a video surveillance showing your client going into the space, with the recovery of items stolen from the complainant's room in your client's space, with the front desk manager testifying that he observed your client leaving the building with the stolen television in question, why under those facts wouldn't, even if you are correct that suppression of the statement should have been granted, why is that not harmless here?
The statement was the only evidence here that showed that Mr. Richardson entered the room. Without the statement—
No, they had a video.
But not a video of him actually entering. They had a video of him leaving with the television, but there would have been a persuasive argument or a reasonable doubt that Mr. Richardson didn't enter the room without permission, but rather could have received this property from somebody else. Turning to the point of custody.
And you think all the other evidence I mentioned, that all of those things coupled together would not have rendered the admission of a statement harmless in any case?
Well, there's the prosecution would have still needed to prove unlawful entry and intent to commit a crime upon entry. And with just the surveillance.
During a trial of this sort, a court clearly would have been able, based on the finding of items in your client's room that belong to the complainant, certainly an inference charge with regard to that, right? And a jury certainly could have considered the fact that his possession of the items stolen is indirect evidence of his having gone into the room unlawfully.
Right, that could be a reasonable inference, but there would also be reasonable doubt about the entry, where there was no surveillance camera on the 5th floor where this took place. There was no witness that Mr. Richardson entered the room himself. There was no evidence of when this theft occurred. Mr. Arias was out of the building for 16 days, and this could have happened at any point in time. So under those circumstances, there was certainly a reasonable doubt as to his guilt of unlawful entry and also the element of intent upon entry.
Okay, you have 1 minute on rebuttal. Ms. Regan, you have 4 minutes.
May it please the court, Amanda Regan on behalf of the people. Although it's the people's position that Miranda warnings were not required because defendant was neither in custody nor was he being interrogated.
Well, let's talk about that. By the time the police officers questioned Mr. Richardson, they had already spoken with the complainant. They had found items of the complainant in the defendant's room. They had already seen the surveillance. They had already spoken with the front desk clerk, who said they watched the defendant walk out of the building with a television set, which was one of the items stolen. And they had the statement of the manager. There was no question that Mr. Richardson was going to get arrested that day. So I don't understand what they were investigating. It was the only thing to elicit was an admission.
Even if the questions posed to the defendant constituted interrogation, because both interrogation and custody are necessary prerequisites to requiring Miranda warnings, such warnings were not required here because defendant was not in custody.
Well, you don't have to be in handcuffs to be considered in custody under our jurisprudence, right? And they did make him come into the building. They did make him go upstairs to the room. So it wasn't just let's talk.
No, Your Honor, I just want to correct something. He was not asked to go up to the room. He was asked to step into the front lobby area, the vestibule, and that's where the questioning took place, which was a pretty big area that the officer described as being about 10 feet by 10 feet. And this was an area that the defendant was familiar with. The defendant was not surrounded.
10 feet by 10 feet isn't a huge space. That's your average bedroom.
Your Honor, but defendant was not, he wasn't surrounded by police officers. But even putting aside the issues of custody and interrogation, as Your Honor has recognized, any error in admitting the statement was completely harmless, because even without the defendant's statement to the police, the people's credible evidence overwhelmingly established his guilt. He was captured on video surveillance and also seen by Wright removing the television, which Continent and Aris identified as the one from Aris's bedroom. This occurred at approximately 5 o'clock in the morning when most of the residents would be asleep. So the clear inference from that is the defendant was trying to covertly do this so as not to be caught. He was also prepared. He was using a hand truck to facilitate the removal. The clear inference from this is that he went to the room with the intention of stealing something substantial, and he needed assistance carrying it out, so he came prepared with a hand truck. And during the subsequent police investigation, some of the smaller items that had been removed from Mr. Aris's bedroom had been recovered inside of defendant's room. So as the jury correctly recognized, the only reasonable inference to draw from this evidence was that the defendant knowingly and unlawfully entered the bedroom, Mr. Aris's bedroom, with the intent to steal from him. And unless there's one other point that hasn't been discussed, but unless your honors have any questions, we ask you to affirm on the brief.
Thank you so much.
Thank you.
Ms. Drifter, you have 1 minute.
Yes, I'd like to address the points of the time that this video was taken at 5 a.m. and also the hand truck. Again, this theft, the entry into Mr. Arias's room, could have occurred during any time within the time period of 16 days. So
Except
the fact
that there was no evidence and there was no testimony elicited that the manager or the front desk clerk saw anybody else leave the building with a television.
Right, so we can see that he left with the building with a television that did not belong to him, but that does not mean that he entered the room. Had the statement not been entered, there would be no way to know how he got the television, and that he got it himself, and that if he did in fact enter, that he had entered with the specific intent to commit a theft upon entry. And in terms of, again, the hand truck, my adversary mentions that this implies that he entered the room to take a substantial piece of property. Again, in terms of when that could have occurred in the 16 days, it doesn't mean that he entered the room with a hand truck. It just means that that's how he left the building with the hand truck.
Thank you.
Thank you.
Banco Indusval S.A. versus Antonio Carlos Gonsalves Jr. Mr. Zelbo, you have 4 minutes.
Thank you. So Mr. Gonsalves guaranteed millions of dollars of his company's debts and refused to honor that obligation. So Banco Indusval in Brazil, under the Forum Selection Clause, brought an execution proceeding. It's akin to our summary judgment in lieu, not exactly the same, but basically it's a procedure when you have clear documents, a loan agreement, a guarantee, promissory note. You can bring an streamlined execution proceeding. And what happens in that, and what happened here, is the court then in Brazil would say, okay, the defendant here, Mr. Gonsalves, is ordered to pay the amount sought, okay? But he can move to stay the execution.
I'm going to stop for a minute because I know this is a very complicated procedure that took place, but we're dealing now with whether a New York court can enforce the judgment. And in the absence of there being a clear sum or amount specified in any of these documents, why should the New York court have to guess at what the amount should be in terms of the judgment, have to go to extraneous documents to ascertain that? In the normal circumstance, which happens all the time, there's a judgment, it's got a clear amount in it, and it's just a ministerial matter to say, yes, we're going to recognize that, which is not the case here.
Well, here, it is ministerial in the sense that there's a judgment which says they have to pay the amount we sought, the amount owed. And there's no dispute on that amount.
What the amount is, this New York court would be required to go look at other documents, which is not what the statute requires. The statute says, basically a judgment certain, which does not exist in this case. There's no piece of paper that says we're entering judgment for $17 million.
This is the way they do it in Brazil, right? When you do this judgment.
Except you're not enforcing in Brazil, you're enforcing in New York. So you have to follow the New York statute. So tell us how the documentation you provided from Brazil meets the standards and requirements of our New York statute, which, sir, is the only issue before this court.
I agree with that completely. The New York statute says it needs to be an order granting or denying a sum of money, right? I can quote
For
the,
some certain. The document must state, as my colleagues have pointed out very clearly, it must clearly state, we cannot engage in a search of the record in order to ascertain what the amount is and whether that amount was appropriate, which based on the record before us is precisely what the bank wants us to do.
the language of the statute, just if I may read it, is to the extent it grants or denies recovery of a sum of money. This order grants recovery of a sum of money, and there's
Counsel, this is Judge Gonzalez, if I may. I think you're skirting the question because looking at the December 17th, 2015 order, it requires Mr. Gonsalves and Ms. Gonsalves to pay the debts of the debtor. There is no sum specified. There's a series of things that they have to do that Seagro, Mr. Gonsalves, and Ms. Gonsalves have to do, but there's no amount. And you can read to us and you can explain to us, but the bottom line is that the court doesn't know exactly what it is that it's being asked to enforce. And we can't go looping around to figure it out because this is supposed to be a foreign judgment as opposed to an order of attachment. Also, if you look at the August 8th, 2017 decision, it's a denial of the motion to stay execution. And even though the defendants were prohibited from selling, transferring, or otherwise disposing of the assets, they were allowed to use the assets. So where is the finality of the foreign judgment that you're asking us to enforce?
well, in terms of finality, and I want to come back to the sum, but in terms of finality, we have to execute on the asset. We have a judgment in the amount we sought in the case. That's what the court has said. And that's what it means to extinguish the motion to stay. You bring a case seeking money, they granted the execution, then they stayed it when they made the motion, then they extinguished the execution, which means we won the case in the amount we sought. Of course, they can use their assets until we seize them, and then we collect on the judgment. That's true in any case. That's the way it works. And the only uncertainty, if there is one, is that interest keeps accruing. And we have in the record at R132, the later judgment of the court, when the appeal was affirmed, okay, which talks about the updated amount is now 81 million reais, at then exchange rates would have been 24.8 million. That's just because of interest is accruing on the loans. But there is a specific amount. We didn't seek the higher amount because there's not that much assets in New York to begin with, and we were trying to streamline this, but the amount.
Well, let's go back to the
Sure.
2015
Yes.
decision. It says that you're supposed to name the debtor. You're supposed to name the debts. You're supposed to submit the motion within 15 days, regardless of attachment or deposit or bond. You're supposed to do all of these things. It seems like this isn't ripe yet to be called a judgment. Would you agree or disagree with that?
I do take heart to discussion that this is a question of New York law in one sense. Finality, like whether it's final, is a question of Brazilian law. And under Brazilian law, as our expert says, it's final. And their expert, who's not an independent expert, he's the lawyer in the case, that's fine. He doesn't say it's preliminary. Mr. Gonsalves in his brief says it's preliminary. Their expert does not say it's preliminary. He says it's procedural because, and I can get to that, but he doesn't say it's preliminary. It is the final order. This is how they do it in Brazil. So under Brazil,
Counsel, I'm going to ask you to wrap up because you are already 2.5 minutes over your time.
Thank you, Your Honor. In sum, it is a final order. That first piece. That's a Brazilian law question, a legal question that can be resolved on summary judgment. And the only expert that's opined on that issue has said it's final. In terms of the form of the judgment.
Thank you. You're out of time. You have a minute on rebuttal. Mr. Levinson, you have 4 minutes.
Thank you. May it please the court. At its core, and I think this, from the questions, I think the court has already recognized this. This appeal is about a New York trial court wisely and judiciously recognizing the limits of its authority and its role within the carefully constructed structure and plain meaning of the provisions of Article 53 of the CPLR. We can focus somewhat on finality, but where the appeal really goes down in flames is on conclusiveness, because this is not for the recovery of a sum of money. You can look high, you can look low on the two orders.
Mr. Levinson, this is for the recovery of a sum of money. The fact that the papers of the Brazilian court do not conform to the manner in which it must appear for a New York court doesn't change the fact that your client owes this money and that a Brazilian court found that.
But
whether they can collect here is the issue before us.
I'm not arguing there, as the court has pointed out. Justice Kotler was faced with a predicament. They're asking her to undertake to rewrite the foreign order to a judge that a particular sum of money is due to the plaintiff when that sum doesn't appear anywhere on the two documents that she has to operate from. She's basically flying without radar. And it is not her job, and all of you sat in trial courts, to forage a foreign record or parse a foreign record to figure out, or she put it, I think it was compute, calculate the amount due. It has to, if the court is going to do the ministerial function of a judging that the foreign judgment meets the standards under 53, and particularly under 5303, it must have that number in the order so that it can take the foreign order, make a New York order out of it, and life goes on. And then they try to enforce here. She can't, it's the burden of the plaintiff, of the party seeking to enforce the foreign judgment to prove conclusiveness. It's not the court's burden, and it's not the defendant's burden. And they didn't meet their burden. They probably can never meet their burden because those two orders have no defined sum of money.
Counsel, just a question. How do you characterize the language that says, name the execution debtor to pay within 3 days, the debts of the debtor? That language from the December 7th, 2015 decision by the Brazilian court.
Though, as the court below found, that order only talks about debts that are claimed in the pleading that they filed in Brazil. And it doesn't have a number, and there is no number. The court has to look at extrinsic documents in order to write a judgment.
I guess what I'm asking you is that if this was in a New York court from the beginning, from scratch, would you say that this was a premature application? It wasn't ripe. It's just not. It's not finalized.
It's both not finalized, and there is no. If you were sitting, if that order were entered in the trial court in New York, and it just said pay the debts of the debtor, and you didn't have before you in the order to affirm it the underlying claim, then you wouldn't be able to affirm it. Now, it's more complicated because their system is different. Mr. Zelbo argued, and I respect him very much, but he argued since they can execute here, they should be able to execute here. Since they could execute in Brazil, they should be able to execute here. That is not how Article 53 works. It has to be a final and conclusive judgment there, and then if you pass through the gatekeeping function, which is Article 53, then it gets entered here as a matter of course. But the court is not a rubber stamp. It is not simply to take the foreign judgment and say, well, it must be there somewhere. I better go look and find the amount. That's not your role or your burden. That's not Justice Kotler's role or burden, and she well understood it. And she gave the second bite of the apple And I just want to say one thing, if I may,
Yes.
which, because I think it's the most important sentence in either of her decisions. This court is not required to step into the shoes of the Brazilian court to determine/compute the amount owed by defendant in order to issue a money judgment. If I leave you with nothing else, I want to leave you with that. Thank you.
Thank you so much. Mr. Zolbo, you have 1 minute.
Thank you. So to go back to 5303, it's conclusive, quote, to the extent it grants or denies recovery of a sum of money. This does do that. It is final in Brazil. Nothing has happened in 3.5 years other than we're trying to collect on it. There's not going to be any merits hearing. This is how they do an execution proceeding in Brazil, and this is what the final judgments look like. And that's what our expert says, and their expert doesn't deny. So we're left with the situation where I understand 5303 applies, and we have to apply our law, but I think we fit within the literal language and under the general principles of comity. You would be telling the Brazilian court, we're not going to enforce this judgment because we don't like the form. And then I just want to leave with this one point.
Other than we're going to accept your judgment, Brazil or any other country, in spite of the fact that it doesn't conform to our laws. So you are suggesting that U.S. laws should somehow bow to the laws of foreign jurisdictions.
With all due respect, no, I'm not saying that. And I totally agree. New York law governs.
That's precisely what you're saying. It's wonderful that for Brazil, the way they have done it works. We have our own statute. And so it is incumbent upon any movement to make sure that the language of the order that you are seeking to enforce conforms to the four corners of the statute you're seeking to enforce it under.
I have no problem with that. And what the statute says, it has to grant or deny recovery of a sum of money. I believe this
Thank you,
does that.
counsel. We've gone through this and you're out of time. Thank you so much.
Okay.
Ging versus Shiami Construction, Atlantic, Koenig Iron Works, and Trison. The appellant, Koenig, goes first. Mr. Cheng, you have 7 minutes.
Thank you very much, Your Honor. Good afternoon. May it please the Honorable Court, Otto Chang for the third-party defendant, appellant, Koenig Iron Works. Thank you very much for the time. Your Honors, the thrust of Koenig's argument is as follows. In many ways, Koenig agrees with several parts of the Supreme Court's decision. We agree with that portion of the decision that held that Koenig was not actively negligent. We agree with that portion of the decision that awarded attorneys' fees and expenses in Koenig's favor as against Atlantic Detail. And while Koenig also agrees with the Supreme Court's award of indemnification as it concerns the payment of a judgment or settlement or award with respect to the second sentence of the indemnity provision of the subcontract, Koenig respectfully submits that granting of indemnification in Koenig's favor should have been unconditional in nature.
What about the language in that particular, you're talking about with Atlantic?
Correct.
So that contract has language, it's a two-part, which is unusual.
Yes.
So first it has a general, all-inclusive type of indemnification, but then the second part has a negligence trigger. So
yes.
You can't get unconditional until and unless there's been a determination that Atlantic is negligent. And when has that determination been made yet? In the absence of that determination, why shouldn't it be conditional?
Yes, thank you for that, Your Honor. You actually bring me nicely to the next sentence. It is a very kind of unique indemnity provision. We respectfully submit that while that portion of the indemnity provision does reference a requirement of a percentage of negligence attributable to Atlantic, we respectfully submit that all of the evidence and testimony in the record established that the only direction in which the negligence can flow is squarely and directly upon the shoulders of Atlantic.
So you wanted the lower court to make credibility determinations and pre-assess what a jury's role would be?
Not, it's, with respect, Your Honor, it's not so much about credibility. Taking the testimony on its face, the testimony on its face establishes
Are you saying that the fact pattern here shows that the only possible negligent party is Atlantic?
Well, in a sense, yes, Your Honor. In that regard, if the Supreme Court held that Koenig was not negligent, if the Supreme Court held that Sciammi was not actively negligent, and if the Supreme Court correctly cited to the testimony of the parties showing that the only party that controlled the means and methods of the plaintiff's work, that installed the steel tubing on which he stood, and that was responsible for his safety was Atlantic, then the only direction in which the negligence can flow, based on the face of the testimony alone, is down to Atlantic.
Leave down below, because did anybody move down below to dismiss all active negligence and 200 claims against everyone, against the various defendants? And if they didn't, then how can we be making that determination now if that's not part of what's being appealed? I mean, if there had been a determination below finding that Atlantic was or was not negligent, and then we were reviewing that, we'd be making that determination. But if there's no, I don't think that's part of what's on the appeal before us. And if it's not, how could we possibly be deciding as appellate court whether or not Atlantic was or was not negligent, so therefore to trigger it, which is what it sounds like you're asking us to do?
Well, the Koenig and Atlantic were third-party defendants in this action, and there, you know, while there were motions by the parties to dismiss the plaintiff's labor law 240 claim and other labor law claims, again, the main claims.
So if no finding's been made below, and no one's asked the court below to make a finding as to the negligence of Atlantic, how can we possibly bite on the argument you're making?
Well, Your Honor, I mean, the underlying motion practice, part of the underlying motion practice was, for example, for Koenig seeking that indemnity over Atlantic, and seeking that indemnity in the sense that the testimony and evidence all establish that the party that was solely responsible for the means and methods of the plaintiff work, for the safety of the plaintiff.
But I thought the Supreme Court
the superintendent.
I thought the Supreme Court dismissed the plaintiff's 200 claims across the board, and so if the court did, then there has absolutely been no negligence findings.
Well, and that kind of goes to what I was saying earlier, Your Honor, is the 200 claims were asserted against F.J. Sciammi. And again, the Koenig and Atlantic were third-party defendants in this case. So the dismissal, if the Supreme Court dismissed the claims of labor law 200, for example, that was against F.J. Sciammi.
And against Hardy Corporation, the architects as well.
Yes, Your Honor. The Hardy defendants are not in this case, and they do not take a position on this appeal.
Could it be no one's negligent? I mean, there could be just 240 liability, which doesn't require any negligence.
I'm sorry, Your Honor, my audio just cut out there for a quick second.
I'm saying there doesn't have to be negligence on the part of anyone for this claim to proceed, because there's a 240 claim, which doesn't require negligence.
Well, again, Your Honor, we respectfully submit the summary judgment that was awarded on 240 was against F.J. Sciammi as against the direct defendant. Koenig is not a labor law defendant, and the claims against Koenig and Atlantic are for indemnity and contribution. Obviously, we join in the arguments on appeal by the other parties against the labor law 240 claim. But what we respectfully submit is on the claim of indemnity under the terms of the subcontract, and based on the testimony and the evidence alone, again, and based on the Supreme Court decision, which we respectfully submit warrants nothing short of the conclusion that, again, as a matter of law, based on the holdings of the Supreme Court, the only party left to which any negligence can be attributable to, as a matter of law, is Atlantic.
I don't see how you can say that based on the decision below and the causes of action that were asserted below. There was no negligence finding by this court one way or the other below.
Well,
so
and-
you're asking us to make that conclusion based on other conclusions having nothing to do with negligence. But
well,
you have a minute. You have a minute on rebuttal. You're out of time.
Thank you, Your Honors.
Okay. Atlantic, Mr. Kaminska.
Thank you, Your Honor. Glenn Kaminska with Omni Demers McManus, counsel for respondent appellant Atlantic. I would like to use my very limited time to discuss the documents here that really make it impossible for the court to have granted 240 to the plaintiff and bear upon the indemnity issues as well. As this court knows, you know the record certainly better than I do, admittedly. This court, the court below rejected multiple documents claiming they were inadmissible, despite the fact that the plaintiff never raised an objection to them in opposition to Atlantic's motion or in reply to Atlantic's opposition. One of these documents, the accident report at 1038 through 1040 of the record, supported by the deposition of Mr. Schottenmuller, show that there was not an accident that actually took place, that he merely tweaked his back while lifting. Mr. Schottenmuller spoke
Is
to
there a
Mr.
fault with the accident report, though, that the person who wrote the report did not speak to anyone about the accident? Isn't that a problem?
It's all
It's not a-
hearsay.
It's incorrect, actually. He spoke to Mr. Mott, and that's at 577 through.
Counsel, it's hearsay. It is a statement, not a court statement of another person for the truth of the matter asserted. It is classic hearsay.
And as a business record, it'd be an exception to the hearsay doctrine, but it
No.
also, there's admissions
No,
against.
hearsay within hearsay. That's not true, Counsel. You know that.
In any event, we see that the plaintiff spoke to Mr. Mott. Mr. Schottenmuller spoke to Mr. Mott. We see
Now
that-
you're talking double hearsay.
And Schottenmuller spoke to Mr. Zapkis, which the
He
court
didn't speak
below
to the
ignored.
plaintiff. He didn't speak to the coworker. He got everything secondhand from people who weren't there.
Well,
He
Mr.
didn't-
Zapkis
he
was
didn't
there.
do a proper
612
counsel.
record.
Counsel.
Moving on.
It is called hearsay. Maybe you want to talk about the other documents that you think
Sure. The
are
emergency room-
admissible.
The emergency room report at 2177 of the record, as quoted by Dr. Spivak under oath at 2182 of the record, under the penalty of perjury, shows that the plaintiff did not, again, suffer a fall.
Counsel,
that
statement, diagnosis or treatment.
Certainly, it would go to diagnosis or treatment. Whether or not you fell or whether or not you strained something is pertinent to whether or not is pertinent to your treatment. Absolutely. And again, we as the non-moving parties are entitled to every favorable inference here. And the court certainly below did not give us that benefit, because even with regard to the accident report, even inadmissible evidence, even hearsay can be used.
So now favorable inferences excuse the admissibility of documents? I've seen no case that holds that.
Well, I think the
either a document
the bishop
is admissible on the four corners of the document, or it's not.
Well, in the Bishop case cited at page 15 of our brief, as long as the hearsay document is not the only proof being submitted, they can be admitted. So here again, we have the C3 document. The C3 document actually signed by the plaintiff at 1044, 1045 of the record. Certainly, this is an admission against interest where the plaintiff admits that he was lifting. Now,
So how does that contradict, Counsel? How does the C3, which arguably is not hearsay, the only thing that's not hearsay, how does that contradict his version of the accident?
Very good. At 1044 of the record, paragraph 6 of the form, where you actually fill out the thing that says, how does the accident happen? And this form gives you an example. The example says, trip over pipe and fell on floor. To which the plaintiff responds, hurt lifting, or words to that effect. He only mentions injured by lifting.
But
never
counsel,
mentions the fall.
wasn't lifting part of what he was doing? Weren't pieces of decking being lifted from the second floor and passed up to the plaintiff, who then had to lift them onto the third floor?
Okay, yes, he was lifting, but if he
So
wasn't,
then where's the
if he wasn't injured
inconsistency,
during the lifting,
counsel? It would really help if you just listened when I ask you a question. How
certainly.
is that not lifting? Where is the inconsistency?
Well, just because he was lifting at the time, it says what happened, the accident happened. He was lifting. He doesn't say he was falling. It doesn't say I was wrapping my legs around a beam to support myself. If the accident happened while he was lifting, then it's the same as everything else. He tweaked his back while lifting. And again,
thank you so much.
Giving us every favorable inference.
Thank you, Mr. Kaminska. Your time is up.
Thank you, Your Honor.
Mr. Rubenstein, you have 4 minutes.
Thank you, Your Honors, and may it please the court.
And I want the record to reflect that I have given everybody extra time because I recognize that these are fact intensive. So I want each of you to know you have each been given at least 2 extra minutes on the time that I granted you at the start. You may proceed, Mr. Rubenstein.
Thank you, Your Honor, and may it please the court. I'd like to start with the 240 portion of the judge's decision, because other than that, this particular portion, Shyami has no issue with Judge James's decision. Breaking down factually the 240 claim, what's significant, focusing on plaintiff's affidavit on 1070 and 1071, is that plaintiff turned to put the piece of decking on the pile and the entire section cantilevered, suddenly dropped and causing him to fall. So at a certain point during his workday, yes, he is lifting, he is hoisting, but by the express terms of his affidavit, he's not actually hoisting or securing anything at the moment of the accident. And
counsel, I am sure that you are aware, having read many of the cases of this department, we do not dissect accidents into that minuscule a moment. And we don't require that at the exact moment of the injury that the injured worker be actually engaged in the activity at the time. And there is plenty of case law that has held that. So I suggest you would be better suited to use your arguments on cases that actually flow from our precedent.
Right, I understand that, Judge, but that point has to be taken in totality with the other points, okay? Which is that plaintiff acknowledged that he fell backwards onto his tailbone and onto the same level that he was working. Secondly, he was not hit by any decking, he was not hit by anything above him. The tube that he was on moved a couple of inches. The totality of those circumstances is what takes this out of the ambit of 240. Not
how
what he's doing at the time.
If the surface he is standing on while working moves, causing him to lose his balance, how is that not 240 and causing
because
him?
He didn't fall off the platform. He fell onto his backside.
Counsel,
that was the end of the accident.
Don't we have a number of cases from the first department saying that it doesn't have to be an actual fall to create 240 liability?
I understand that, Your Honor. But the point of my argument, and I believe that on behalf of all the defendants who are opposing the 240 finding, is that the totality of these circumstances is what takes it out of the ambit of 240. And that's what's significant about that. If you separate it out and look at each piece individually.
Counsel, if you look at it, I don't know how to pronounce it, Ribelli or Ravelli, from this department in 2011, a worker may recover under 241 if he's injured in the process of preventing himself from falling. Preventing himself from falling includes wrapping his legs around what I believe was a cantilevered surface. Am I right?
Yes, Your Honor.
So he's at a cantilevered surface, which means that one part is not affixed to anything, and he has a safety harness and a lanyard that can't be tied off. So instead of letting himself fall, he wraps his legs around the surface, the tube that he's on. That falls squarely within the protection, the ambit of 241, doesn't it?
Your Honor, I respectfully disagree based upon the totality of the circumstances surrounding the accident. I'd like to just move on to the other portion of Sciami's brief, which is
you have one more minute.
Which is in opposition to Koenig's, that portion of Koenig's brief that has to deal with the anti-subrogation rule. And I just want to point to the court's attention that Judge James's decision in this regard is absolutely correct and should be upheld on appeal. Most significantly, Judge James quotes heavily to Gallagher v. New York Post. And what's significant about that is that A, that's correctly decided. B, the facts of this case fit squarely within Gallagher. And most significantly, counsel for Koenig took no steps to distinguish this case within Judge James's decision as wrong or incorrect. So therefore, there is no basis for this court, no persuasive basis for this court to upend that portion of Judge James's decision with regard to the anti-subrogation rule and the stacking of insurance policies vis-a-vis Sciami and Koenig.
Thank you so much. Respondents Counsel, Mr. Cameras.
Good afternoon, Your Honor.
Sorry, I wanted to try, but I just knew I wasn't going to do it.
I don't want to say cash my check, but Casma check.
Casma check. Okay.
You know,
thank you.
Thank you, Your Honor. I've always done my name very well. As we've heard in all the cases that we listened today, it's evidence. It's whether it's the Brazilian case or the case on the police. What makes justice justice is not people wanting to interpret from paper or documents later on their findings. The documents here that were not used by the court, that the opponents on my other side could have questioned the plaintiff on, could have questioned other people on. They all know how to do appeals. They could have subpoenaed witnesses. They could have done what the whole CPLR allows. They did not do that. They come now and say, oh, those documents should say this. Evidence and justice says, well, you know, they really mean this. And if we have put a bunch of hearsays together, it makes it a small H instead of a large H. You know, I won't burden the court. I appreciate the other time you give it to the other parties, and we respectfully request conclude right now, Your Honor.
Okay. Do you have any arguments with regard to the all the cross motions concerning indemnification?
No position, Your Honor.
Thank you. All right. Starting again from the top, Mr. Cheng, you have 1 minute.
From the top, thank you, Your Honor. Just very briefly, as it concerns the Labor Law 240 claims, I obviously join in the arguments made by Mr. Rubenstein and Mr. Kaminska. The only real point that I have to respond to on reply, Your Honor, is just to Mr. Rubenstein's point about Gallagher versus New York Post. In our responding reply brief, we did actually distinguish that case. We respectfully submit to the court that the difference between Gallagher versus New York Post in this case, as it concerns the claims between Sciami and Koenig, is that the claims in Gallagher involve the granting of indemnity against a plaintiff's employer for the exposure beyond the primary 1 million because the employer failed to provide the plaintiff with a safety device and was therefore negligent. Here, the Supreme Court correctly held, one, that Koenig was not a labor law defendant, and two, Koenig is not even the employer, and three, most importantly, that Koenig was not negligent. That was the only point I wish to respond to on reply. And again, I join in the other arguments on Labor Law 240, and I thank you for the time, Your Honors.
Thank you so much. Mr. Kaminska, you have 1 minute.
Thank you, Your Honors. Koenig failed to make a prima facie case in its initial motion seeking indemnity by failing to support anything about the indemnity agreement with an affidavit of one with knowledge. On reply, we get a affidavit from Mr. Morzetti saying custom and practice, but the documents in the record simply refute any custom and practice. Looking at 1606 through 1611 of the record, we see a variety of documents with different dates, none of which will demonstrate a simultaneous signing, as Mr. Morzetti alludes to. At 1606, we have the confirmation of the contract, which is dated March 22, 11, but the indemnity contract purports to be a 2012 date. At 1607, we see Mr. Morzetti sign the confirmation, but that's undated. Mr. Torres signs it February 7th of 2012. But at 1609 of the record, there's an email between Torres and Morzetti of May of 2012 about the indemnity agreement. Now, if it was signed simultaneously when the contract was entered, as Mr. Morzetti says, the custom and practice in an effort to get the indemnity agreement before the court, certainly there would have been no need for a May 2012 letter. Finally, at 1611, we have a certificate of insurance that shows that Atlantic added Koenig as an additional insured on its policy, but that's dated June 19th, 4 or 5 days after the accident. So there's no proof that there was an indemnity agreement to give them any award at this juncture. Moreover, there's questions of negligence. As the fabricator of the steel, Koenig had the obligation to build the steel appropriately. What we've learned from Mr. Ging's testimony at 319 to 322 of the record, that these tubes were fabricated in a way that left them susceptible to shifting, which would make Koenig potentially liable as a matter of negligence, and again, indemnity not be granted. Lastly, Your Honors, because I'm a glutton for
30 seconds,
because I'm a glutton for punishment, I would refer again to the, at least on the C3 document. That is certainly, it's a travesty of justice.
Counsel, I'm going to stop you there. You covered that on your initial argument, and you're out of time. Mr. Rubenstein, you have 1 minute.
Thank you. I just want to address Koenig's indemnity argument. First of all, the distinguishment of Gallagher on their reply is too little too late. Secondly, the fact that Koenig is not plaintiff's employer has no bearing on this analysis and is a pure red herring for the court. And I would just draw the court's attention to Shiami's brief, which goes into whether or not there's a third party, which is the essence of the anti-subrogation rule. That standard is clearly met, and the decision by Judge James in this regard should not be disturbed.
Thank you so much, gentlemen. Have a good night. Steph Lee Associates LLC versus Wiener Architecture Group LLC. Mr. Myers, you have 4 minutes.
May it please the court, Eugene Myers for appellants. The contractual indemnification claims should have been dismissed because the indemnities do not encompass third-party plaintiff respondents' pre-indemnity breaches of lease to the plaintiff. The plaintiff asserts that Steph Lee is liable for failing to perform landlord's work prior to the commencement of the lease in April 2018. Specifically, the plaintiff asserts that the premises was not delivered with gas service supplied by a 2-inch line and a watertight ceiling. In the third-party complaint, Steph Lee asserts that to the extent that it is found liable for failing to perform landlord's work, it should be indemnified under the indemnities that became effective after Steph Lee's deadline to complete landlord's work in April 2018. The indemnities do not have any retroactive application and expressly refer to future work to be performed by the appellants. The indemnities not expressly apply to Steph Lee's breach of the lease obligations to its tenant, and under Hooper Associates, I believe that the indemnity should be read strictly construed. The third-party claims for contractual indemnification, if proven, would preclude liability on Steph Lee's part. Accordingly, the remaining third-party claims are improper under CPLR 1007, which only permits a defendant to plead into a primary action a person, not a party, who is or may be liable to him for all or part of plaintiff's claim against him. Further, the liability sought to be imposed upon a third-party defendant must arise from or be conditioned upon the liability asserted against a third-party plaintiff in the main action. The third-party plaintiff asserts that it fully complied with its obligations under the lease and that appellant's incompetence was an proximate cause of the plaintiff's losses. If Steph Lees proves its theory, it would defeat the plaintiff's claims, and therefore it would preclude liability and there would be no liability to be indemnified for. Assuming the third-party complaints allegations are true, Steph Lee would necessarily be precluded from liability, cannot impose liability on the third parties. And Steph Lee's liability and the appellant's liability are mutually exclusive. If Steph Lee proves that the conduct of appellants as plaintiff's agents were the proximate cause, in whole or in part, of the plaintiff's damages, then Steph Lee would not be held liable and there's no liability for appellants to indemnify. However, if Steph Lee is held liable for failing to provide a functional gas line, the court would necessarily have to determine that neither the plaintiff nor its agents, the appellants, frustrated Steph Lee's ability to perform its lease obligations. In that scenario, Steph Lee's liability would not arise out of appellant's work, and the indemnities would therefore not apply because their scope is limited to liability arising out of work to be performed by appellants. If there are no questions, I'll conclude my presentation.
Okay, I'll reserve your time for rebuttal.
Thank you.
Mr. Henry, you have 4 minutes.
Good afternoon. If it may please the court, Kenneth C. Henry Jr. for the respondent, third-party plaintiff, Steph Lee Associates, LLC. Once the respondent installed the gas line, its obligations under the lease were fulfilled.
Is that what the lease said?
The lease said there would be a, quote, 2-inch gas line, unquote.
No, the lease said more than that.
With regards to the gas line, it referred to 2-inch gas line.
Counsel, if you satisfied that obligation, then the case is done. Because the lease provision only refers to when they take possession, not when Taco Bell opens, not later on when they take possession. So if your client complied with the provisions at the time they took possession, then there'll be no verdict against you and no basis for indemnification. So anything that happened after they took possession is really not germane because the lease is only referring to what your obligations are when they take possession. So how can there possibly be a valid indemnification claim?
Well, with regards to the roof, our JFZ, one of the appellants and third-party defendants, did construction on the roof, literally putting holes into the roof, and that was post signing of the lease.
Counsel, if you can prove that it was things the contractors did after the tenant took possession that caused the damage, then there will be no verdict against you. The only verdict that will be against you, if there is a verdict, is for what the condition was at the time the tenant took possession, because that's what the lease requires. So if your client fulfilled its obligations, there'll be no judgment and no basis for indemnification. So if you can prove ultimately in this case that the contractor did something or the architect did something after the fact, then there'll be no judgment against you and no basis for indemnification.
Well, we are also entitled to our attorney's fees under the indemnity agreements. So to the extent that JFZ caused the damages, which are
liable, the indemnity only comes into play if you are found responsible for something someone else did. And if you're not ultimately found responsible, how does the indemnity come into play?
Well, with regards to the attorney's fees, if the action, we were sued because of what JFZ did. That's the allegation. It was because they put holes in the roof, which caused the leak, which is what the plaintiff complains of. So if it's ultimately proved that JFZ is the party that caused the damages, and even we would be entitled to our attorney's fees for defending this action from JFZ under their contractor's indemnity agreement.
Is that
so
it? Oh, okay.
I was answering the question, Your Honor.
All right, no, go ahead. You paused. So just asking. Go ahead.
No, I have no more, with regards to responding to the question, I have no more to say with regards to that.
Okay.
At this point, we still don't know what degree of, to what degree the plaintiff's contractors, the appellants in this case, obstructed or caused the issues with regards to the gas line and the roof leak. And at this time, it's premature to dismiss their claims. And with that, we say the order should be affirmed, and I yield my time.
Thank you. All right. Mr. Myers, you have 2 minutes.
Counsel, could you
Yes, I
respond
just-
to the question
sorry,
about
go ahead.
fees and the indemnification agreement?
Yes, the attorney's fees are not an independent contractual obligation. It's part of the indemnification of liability. So it requires first for Stephley to incur liability, and then that the liability was a result or had anything to do with the actions of JFZ. Now, if the liability that Stephley incurs is because it did not provide or deliver the premises with the gas line and the watertight ceiling, then it predated the indemnity. The indemnity had no application to that work, and there was no work performed by these contractors, and therefore the indemnity wouldn't apply. And the attorney's fees, which is part of, requires first there to be liability, and then that the liability arise from the work performed by these contractors, and only then would they be entitled to attorney's fees, not just generally as an independent contractual obligation to Stephley. I have nothing further.
Thank you so much.
Thank you.
Okay, and last but not least, Herrero versus 2146 Nostrand Avenue et al. We start with Mr. Smith for appellant respondent 2146 Nostrand Avenue. You have 5 minutes, sir.
Thank you, and good afternoon, Your Honors. May it please the court. I'm Steve Smith. I represent the, we'll call them the Nostrand appellants, 4 in total. There are a number of issues that we brought before the court on appeal, so I'll jump right into the first issue, which is reversal of the granting of summary judgment to plaintiff on Labor Law 240. The law is well settled that if a plaintiff has adequate safety devices readily available for his use, that he knows that the adequate safety devices are available, and for no good reason fails to use one.
Counsel, could you stop right there and
Sure.
just talk about the knows that the safety devices were available and that he was expected to use them? Because you're quoting straight from Cahill. So let's talk about that part, because it appears to be a question as to whether he knew that they were available and he was required to use that particular safety device.
First, what I would say as to whether he knew them, the record is replete with evidence that he knew exactly where they were.
You have a little time. Why don't you focus? The issue is not whether he knew. He used the scaffold the day before. The question is whether what evidence is there in the record that he was told he could not use the equipment of other contractors?
Okay. Thank you for asking that question, Your Honor, because what I would point to in that respect is that the cases that we referred to in our brief, Torres, Cherry v. Time Warner, Robinson, noticeably absent from those decisions, at least insofar as the court found either an issue of fact or actually affirmatively sole proximate cause, was a direction from a supervisor directly to the plaintiff saying, don't use other equipment or only use this equipment. The focus on, I would submit, the focus in those cases and what the law holds is, were these devices available? Did they know the devices were available?
Counsel, that's not the issue here. And attempting to frame it that way is not going to change our view of it. He knew that there was scaffolding available. The record shows he used it the day before. So that's not the issue. The issue is, where in the record is there evidence that he was told and directed to only use his company's equipment and never to use the equipment of others?
Right. So, I mean, the simple answer to that is that there is none. But my response, if I may, add a caveat to that, is that the law does not require that in circumstances like this. The reason I keep harping on the availability is not to dodge the question,
but counsel, Cahill is, you have to read it with Biaco Neto, which says, did he know he was expected to use the safety device? And here you have a foreman, the plaintiff's foreman, Mr. Ehman, who stands 10 feet away from the plaintiff while he is using the other trade scaffold and says nothing. So how did the plaintiff know that he wasn't supposed to use the borrowed scaffold if his own foreman said Zippo?
Well, what I would say to that is that there was no in these unique circumstances, there is no legal obligation under the law for his supervisor to have said that because of his experience at the job site and because
Counsel,
of his
the standard is that he had to know that he wasn't. That's the legal standard. So you're trying to ignore that legal standard in your arguments. For you to be successful or create an issue of fact, you have to have some evidence that he knew he was not supposed to, or your claim fails under the legal standard. So I'm not sure how you think you can bypass that legal standard.
Well, what I would just, I know I sound like a broken record now, but what I would stress is that the various cases that we discuss in our brief, Torres out of the 3rd Department, Cherry out of this department,
all which predate Biaggi versus Neto, which I was on, a case that I was in the dissent in this court, and which the Court of Appeals agreed with the dissent. So there's no way you're going to get this court to not follow that case.
I just would, again, respectfully submit, Your Honor, that the evidence shows that he clearly did know he was supposed to use his employer scaffolds based on his experience and training. Whether or not there was an explicit instruction from his supervisor is not something that I would submit is required by the law. Whether he knew.
Thank you. Your time is up, sir.
Okay, thank you, Your Honor.
All right. Mr. Zafanti, you have 5 minutes.
Hi, may it please the court. My name is Dominic Zafanti. I represent the respondent appellant Shawmut. A lot of issues on this appeal. I just wanted to touch on the Labor Law 200 issue. The plaintiff was using a scaffold that at this point, nobody knows who owned the scaffold, but we can rule out some people who didn't own it. His employer did not own it. Shawmut also established that it was not Shawmut's scaffold. They didn't have any scaffolds on site. Under the prevailing case law, liability for Labor Law 200 involving a defective or allegedly defective scaffold has to be analyzed as a means and methods type accident.
Counsel,
unless 200 is not an issue.
Both. Why isn't this both? Why isn't this a dangerous condition and a means and method? The dangerous condition being the scaffold itself, which was dangerous. And why isn't there then a factual issue as to whether your client had actual or constructive notice of the defective condition, since there was testimony that it didn't meet factory specifications, which would have been observable just from looking at it. So why doesn't all those things together, at a minimum, raise an issue of fact as to whether there'd be negligence on the part of your client?
Okay, thank you, Your Honor. A couple issues there. With regard to whether there would be a dual analysis as to whether a dangerous or a defective scaffold would also be analyzed under a notice issue. The case law speaks to that. The Court of Appeals case in Perishkili. More recently, there's a Second Department case, Ortega, which while it's a Second Department case, the First Department has adopted it, and actually the cases that I was just looking at in 2020, there's a case out of this court. It was Nassar versus Macy's, and it dealt with that kind of issue. And the issue was that.
But counsel, don't you have a problem because Shawmut's superintendent, Mr. Burke, testified that a scaffold without a factory platform would be categorically unsafe? the factory platform is what guarantees that the platform has the required load rating and fit. Isn't that what my colleague is referring to, that those ratings would be readily observable? And your own, not you, but Shomet's own person said, yeah, this is important. And here you have don't you have a dangerous condition off the bat?
No, Your Honor. There's two issues there. Is the first issue is the analysis and whether or not
The analysis comes from your person.
Yeah.
That factual analysis comes from your person.
No, Your Honor, I'm referring to the legal analysis. Under the case law in Perishkili, and Ortega deals with that very, very closely. In the case, even if there's a dangerous or defective scaffolding, it still gets analyzed as a means and methods case. And that's going back to the 1960s.
Really?
Yeah, the name of the case is Perishkili. I cited it in both my briefs. I can quote it.
There is so much case law that contradicts what you just said that I don't see that carrying the day.
Okay. There are cases that deal with when you have two separate when an accident involves two separate hazards, where you can analyze a case as both a means and methods case and also a dangerous condition case. There's a first department case I believe I cited in my brief that dealt with, there was a lighting condition which was a dangerous condition, and then there was a leaning door which was a means and methods condition. But so those cases warrant the dual analysis. But on this particular case, there was really only one alleged defect. The alleged defect was an issue with the scaffold. And the case law that I cited, all the case law in my brief, including the Court of Appeals case law, is very clear that has to be analyzed as a means and method case. But I would like to move on to, I did argue in the alternative.
Time, unfortunately.
Your Honors, thank you very much. I rest on my briefs.
Thank you. Mr. Zagarelli, you have 3 minutes.
Thank you, Your Honor. I'll be lightning fast. I'll keep it simple. I've got JD Consulting, DBA Donaldson. I was the employer. This is a case about shared responsibility. Okay, it's undisputed that non-factory platform, which made the scaffold defective, was detectable to the eye upon visual inspection. This is one of those cases I submit that does in fact implicate both means and methods and dangerous condition standards, as Judge Gonzalez indicated before. Through their various representatives and employees, the Nostrand defendants and Shamat maintained a regular presence on site. They conducted on-site walkthrough inspections that put them on at least constructive notice of the visibly defective condition of that scaffold. That creates questions of fact as to whether or not they were negligent in not taking that scaffold out of service. And I'd like to allude to what Judge Gonzalez also mentioned moments ago. Shamat's project manager, Catherine Douglas, she testified that Shamat had a duty to and did in fact inspect the trades' equipment at the beginning of the project. She said point blank that had she seen the scaffold in that condition, she would have taken it out of service. That's at the record 715 to 716, 803 to 804. I submit that those questions of fact preclude summary disposition of the contractual indemnity claims against Donaldson. And unless a member of the panel has a question for me, I'll rest on my brief. Thank you.
Thank you so much. Okay. Mr. Lipsky, you have 4 minutes.
Good afternoon, Your Honors. I'm also going to try to be lightning quick here. I'm just going to focus on the Nostrand appellants seeking a contractual conditional indemnification against Trizen. We're asking this court to uphold the lower court's decision that ruled that the Nostrand defendants did not properly authenticate that contract. In addition, there's other reasons as well, which the court did not get into, the lower court did not get into, such as there actually is no evidence that Trizen owned this Baker scaffold. In fact, the evidence is otherwise. Trizen had black scaffolds as per the affidavit, and this scaffold was yellow and orange. The scaffold also, the name on it was Caruso. Obviously, my client's name is Trizen. My client did not have any employees or workers named Caruso. And there's other reasons as well within our brief, but for purposes of being concise, because I know it's getting late in the day, unless the court has any questions, we'll rest on our brief also.
Thank you so much. Mr. Fingston, you have 4 minutes. We cannot hear you if you are talking.
My apologies.
No problem.
I
There
was
you
going
go.
to take care of before I started and neglected to, so I apologize.
Not a problem.
Again, may it please the court. My name is Neil Fingston here for the plaintiff respondent. I'm going to confine my comments, certainly unless the court has questions, to the points raised by my colleagues. There's no evidence that Mr. Herrera was told to use only Donaldson scaffolds, and also no evidence that he was instructed that he could not use other contractor scaffolds. In fact, Mr. Emin admitted that he, quote, can't be sure, unquote, that there was even a rule which prohibited employees from using, Donaldson employees from using other scaffolds from other contractors. Mr. Emin couldn't establish that Donaldson employees hadn't done that previously prior to Mr. Herrera's accident. So there's a complete void of evidence that Mr. Herrera was directed to use anything, to use the Donaldson scaffolds or not to use the one that he saw assembled in the basement, which he had seen the day before. Also, Mr. Emin is 10 feet away from him just prior to the accident and never tells him not to get on that scaffold. With respect to the Labor Law 200 claim, which Shawmut's counsel addressed, I'll address that very briefly, in addition to the other points that were raised by other counsel. It was also Shawmut's responsibility under their contract to control the means and methods of at the work site. That included the construction equipment in particular. Ms. Douglas testified that the work that Mr. Herrera was doing at the time of his accident was an accommodation to Shawmut. That's further evidence of, in our opinion, of control of the means and methods employed here. So we would contend that there are questions of fact as to 200 liability, Labor Law 200 liability of Shawmut as well as the other defendants. Thank you.
Thank you so much. This concludes the session of the Appellate Division First Department. I hope you all have a wonderful afternoon on this beautiful sunny day.
Thank you.
Thank you, Your Honors.